This next panel is absolutely packed with passion and excitement and knowledge and wisdom. And so it is my great honor to welcome State Representative Meg Froelich, who has been a friend of mine for, I don't even know, Meg, how long we've known each other, but I was delighted when she was elected as state representative. She has represented House District 3 since 2019. Her district includes Sheridan, Inglewood, Cherry Hills Village, and Denver. She's chair of the House Transportation, Housing, and Local Government Committee and a member of the State Civic, Military, and Veterans Affairs Committee, the two committees with the longest titles and the most bill hearings. And I know how long those hearings go. During the 2022 legislative session, Meg passed the Reproductive Health Equity Act, the RHEA bill, to safeguard all reproductive rights, including abortion. In 2024, she sponsored Proposition KK, the referred ballot measure to add an excise tax on the sale of firearms and ammunition. The proceeds from that tax will help victims of violence as well as veterans and school safety programs. Representative Froelich is equally passionate about preserving Colorado air, land, and water, reducing pollution, and protecting pollinators. She is passionate about everything that she does. So there's nothing that she does halfway. Prior to entering politics, Meg worked as a producer for CBS News, A&E Network, and PBS. She was the co-producer, writer, and director of Strong Sisters, a documentary about female legislators in Colorado. She previously served as director of the Colorado chapter of NAREL, Pro-Choice America, and executive director of the Colorado Democratic Party. Meg earned a Bachelor of Arts degree in history from Bryn Mawr College, followed by a Master of Arts in history from the University of Michigan. She earned a teaching credential in secondary education from the Dominican University of California. We are honored. We are so excited to hear what you have to share with us today, Meg. So welcome and take it away.
Thank you, Senator Todd, so much. Thank you, AAUW, for putting on these great panels. Really appreciate being here. I was asked to talk about Prop KK, which I'm delighted to do because this was one of my proudest moments at the legislature. So just to give a little background on why we pursued this avenue, that we had a crisis in federal funding for domestic violence agencies. And that stemmed, actually, not surprisingly, from Trump era policies. The money traditionally that went from the Victims of Crime Act came from prosecution of white collar crime. And so during the Trump administration, there was a decision made to sort of roll back prosecution of white collar crimes, whereas the Obama administration had some really big cases where they brought in a lot of money into that Victims of Crime Act fund that then went out to community organizations to help victims. And this is folks in DA offices, sheriff's offices, as well as community organizations that address domestic violence, and so it's domestic violence shelters, and all of that funding came from the Fed. So it reached a high during the Obama administration, and then the money dried up, and then the Biden administration kind of tried to get it back, and so they funded, I hope this isn't too boring, but anyway, they funded it at a high of 56 million. Then it began to drop steadily, so that, I'm trying to think, the Obama administration hangover reached a high of 56 million, and Elizabeth, who's joining me on the panel, can say. But anyway, at the point at which we proposed Prop KK, we were down to 17 million and looking at even less. So absolutely difficult for the over 200 organizations that were funded through that in Colorado. So we proposed a tax on guns and ammo at 9% to fill that backfill. And in addition to funding domestic violence, we proposed addressing veterans' mental health, a little bit of school safety, and youth mental health. And that really helped us strengthen our coalition and broaden the number of folks who would benefit from this. Um, and of course, as you guys know, because you folks know, because you're so up on Colorado, you understand why with Tabor we can't backfill when we lose funds from the feds. And thanks to Tabor, we just don't have any excess in our budget because, of course, any revenue above our Tabor cap is returned to the taxpayers. So um, the good news was we had a Majority Leader Duran, who you just heard from, so you know she's a force of nature, and her lived experience is so incredibly powerful to help us pass this measure. And and that highlights, I just want to say with a big exclamation point or asterisk, how much we have benefited in Colorado from the changing demographics of the legislature. So folks like Sue Ryden and Nancy Todd, who ushered in our number 2 place in the nation in terms of percentage of women serving in the legislature. So we have led the nation in percentage of women. We battle it out with New Mexico and Vermont. And New Mexico is now, unfortunately or fortunately for them, or is it Nevada? I should know. But anyway, has surpassed us. But this lived experience means that we have folks who have lived experience of being unhoused, of sexual assault, of domestic violence, of all the whole full range of their reproductive life. And so that translates into an absolutely different agenda and a different way of doing business. But we can't get too far off of KK. So we had a couple of really big hurdles, and we hit the first one in the Senate. And this is actually interesting for AAUW to hear about because it was truly an astounding moment. The bill was set to go to health, and the chair of health, Senator Mullica, disagreed with the policy, didn't think that guns and ammo should be taxed, and that proceeds would go to domestic violence. And so he wouldn't schedule the bill. And the clock is ticking. As you know, we have 120 days. You got to get it done in 120 days. So the clock is ticking, and you need 3 days to make it through the second chamber. And so we had to go into negotiations and basically do what he wanted in order to get the bill heard, and he wanted it reduced to 6.5%. As we said, the clock was ticking and we needed the bill to go in, so it was reduced in committee to 6.5%. That was a loss of almost $20 million anticipated loss. So then it led to a difficult passage through the Senate because there were folks that agreed with the senator on that it wasn't a good policy. So we only squeaked out of the Senate with 18 votes, went back to the House, held our nose and approved it at 6.5%. So that was our first hurdle. We covered that. Then Representative Duran and I, Majority Leader Duran and I just happened to be on another bill together on wage theft. The governor vetoed that bill, and then Labor held a big rally protesting the veto, and then Representative Duran and I went into the doghouse with the governor for that Labor rally, and so there was no bill signing ceremony for Prop KK. And we had really hoped when the governor signed Prop KK, which he did, sending it to the ballot, that there would be that would be our moment to launch the campaign, and we would get some earned media at that event, and we would sort of say, look how great this thing is. So that opportunity was not there this summer, so we're trying to get the word out on Prop KK. So that was our another challenge. Then we entered a really crowded ballot, as you guys know, because you voted on all of those things and you held panels and information sessions on that really crowded ballot. And then because of that crowded ballot, it was a tough, and the other folks on the panel will attest to this because they powered through all of these challenges. That was really hard to fundraise for this ballot measure. In addition, most ballot measures, and we could do a whole Saturday morning on the weaponization of ballot measures from moneyed interests. But most ballot measures have some really, really wealthy folks that really, really want that ballot measure. That's not the case in the domestic violence and victims' rights area. Most of our donors to our organizations and to our advocacy organizations are survivors themselves. Nobody is really in the millionaire billionaire class among those people. We managed to raise enough money to run a robust campaign, but it was grassroots, digital, non-traditional. So what's the good news? We had the advocates who you're going to hear from as well. We had folks like AAUW who saw the merits of the ballot measure and endorsed it. And I think one of the really big things was it was very simple ballot language. We saw with 131, for example, on the ranked choice voting and ending open primaries or opening up primaries. Very confusing ballot language. We heard from a lot of people who disagreed that this ballot language was pretty black and white. That it was, let's talk guns and ammos. Here's where it's going. Here's what the anticipated revenue, and again down from 54 million to 39 million because of that drop in the percentage. But clearly outlined where it was going and where it was coming from, and that it was an excise tax, not a sales tax, which is a difference, a distinction that was important to some people. And so we had a lot of DAs and the Attorney General, a lot of good folks saying good things about it. And so we prevailed, and we were the first in the nation to send a ballot measure like this to the people, and the first in the nation to do it successfully. And now everyone is knocking down, particularly Majority Leader Duran's door to see how it was done and can they do the same thing. California passed this same idea, but they are able to get it through their legislature. But as you know from Tabor, anything dealing with taxes has to go to a vote of the people. So we're tremendously grateful that we were able to do that. And I think it was a good year in Colorado across the board. And of course, Amendment 79 was our big change to the Constitution in terms of reproductive rights. And that campaign was robust. And they co-campaigned, they put out a lot of literature that had marriage equality and Prop KK on it as well. And then there were a lot of legislators like me who had Amendment 79 and Prop KK on their literature and on their campaign as they went out and campaigned across the state for their own reelection. So that I want to be as quick as possible to allow the real experts to address you and also to leave time for questions. But very grateful to folks like AAUW who not only stay engaged, but also chime in when it's really important and help things like Prop KK get over the finish line.
Meg, that was great. And again, I want to encourage people to enter the Q&A. And at the end of this panel, we'll come back and ask questions so that we can hear from all three of these experts. And so again, the enthusiasm and the passion that we just heard from Meg is a big reason for why KK passed, and also why so many good things are going on at the legislature. So thank you, Meg. And we'll ask you to stand by because we'll have the next two panelists come along. So our next panelist is Shelly Dill, and Shelly and I go way back to when she was in high school. And so I know her on a personal level, as a mom, as a wife, as a friend, as a niece, and as the only thing that I have concerns is that her experience at Baylor, because they're playing my Jayhawks today. And so other than that, Shelly, you and I are on the same wavelength. So with that, I welcome Shelly Dill. She is the senior attorney in the New Leaf Family Law Firm. She practices in all areas of family law, including civil protection orders, child custody disputes, and other matters such as stalking and harassment. She also has experience with domestic violence, mental health, special education, and addiction issues that create complexity in cases. Shelly believes in the importance of pro bono work and takes pro bono cases for her firm. She also has created and directed pro bono projects aimed at serving victims of domestic violence. Shelly has served on the board of the Colorado Women's Bar Association and the Board of Governors for the Colorado Bar Association. She received her Juris Doctorate degree with honors from American University in Washington and Washington College of Law in Washington, D.C. She also holds an MA from American University's School of International Service in Political Economy, an MA from the University of KwaZulu-Natal in Economic Development, and a BA from Baylor University in International Relations. We are thrilled to have you with us, and we know that this has been a busy time for you and your family, and so we appreciate very much you joining us today. So hold on, folks. Get ready for Shelly Dill.
Thank you. Can everyone hear me? Can you all hear me? Okay,
Yes.
good. Excellent. Well, Nancy, I really appreciate that introduction. It's lovely that you got to introduce me. So thank you. I'm glad to be here. As Nancy said, I'm an attorney. And so my perspective here today is a little bit different. I'm going to hopefully, I'm going to hopefully move into my presentation. Yes. The first thing I want to talk about is a case called Town of Castle Rock, Colorado versus Gonzalez. Some of you might be familiar with this case. It's from 2005. Back in 2005, I was a bright-eyed law student in Washington, D.C., who did not live in Colorado and did not practice family law. And in this case that was from Colorado, it went up to the U.S. Supreme Court. The question that was at issue was, do police have a constitutional duty to enforce court-issued protection orders? This was a heartbreaking situation of the murder of 3 little girls by their father. In May of 1999, Jessica Gonzalez received this protection order here in Colorado, a civil protection order that protected both her and the 3 children. There was significant domestic violence, and the girls went missing after the protection order was received. Jessica then tried to report them to the police that the girls had gone missing and asked the police to enforce the protection order. She reported that multiple times. Heartbreakingly, she had direct evidence that the father had taken them in violation of this protection order, and the children were later found murdered by their father in his truck. Jessica proceeded to become a great advocate, and someday I'd hope to meet her, but the court found the police do not have a constitutional duty to enforce court-issued protection orders. And I was a law student hearing this and reading about this and thinking, what on earth why would that be the case? How can it be that someone in the state of Colorado could get a protection order, could have a judge that would find that there had been violence, that there was a danger, that person would then go to the police and not have the police enforce the protection order? It was just a shocking revelation to me as a law student. So now we're going to shift to talk about VAWA. VAWA, as we know, focuses on domestic violence, sexual violence, stalking, dating violence, any kind of intimate partner violence. And just to be clear, I am a practitioner. I'm a lawyer. I really do not work in the advocacy realm. Sometimes I touch upon it, but I'm a lawyer. So this is from a lawyer's perspective, even though I have worked and with and at a lot of the agencies in our state. And I've been an attorney now for 19 years. So for a large chunk of all of my legal career, we've had the Violence Against Women's Act, but we can see from where we started in that first case that I mentioned that we have moved the sort of the pendulum. Now I would say, expect our police officers to enforce protection orders. We expect our judges to be trained. We expect lawyers to be trained. And a lot of that is directly due to VAWA and the initiatives of VAWA and the funding streams of VAWA and the hard work of a lot of people that are here today. And of course, I have, as my legal practice has been a beneficiary of that. I've had my own firm where I've received funding to represent clients, victims, and I prefer survivors, in a lot of protection order proceedings throughout the state of Colorado. And so that's, what I'm here to talk about today. What is the scope of what we're talking about? I mean, there are between 2 to 3 million civil protection orders issued a year. That's not the greatest statistic because it's a wide range, but I'll be honest, it's hard to get really good statistics to know just how many protection orders are issued. And a protection order is one of the responses to intimate partner violence. Another piece of sort of legal protection is a no contact order that you'll often see that will be issued in, say, a divorce case or a custody matter. That is not nearly as strong as a protection order, and I can explain why, but it is another order that you see judges issue. There are also communication platforms that really limit communication, especially emotionally abusive communication that includes that coercion and control. The best one that I've seen is called Civil Communicator, where there's actually a third party that is actually changing and monitoring and the language that goes from, say, the aggressive party to the non-aggressive party, and will kick back the messages. And I've got to say, that's a game changer for a lot of my clients that suffer from emotional abuse and domestic violence. And so it's important for us to know that things like that exist out there as tools to help people. And then, of course, as say a divorce is filed or a custody action, a case management order goes into effect. That case management order will say that the parties cannot interfere with each other's enjoyment of life, that there should be a civil proceeding going forward as parties have conflicts. There's also a mandatory financial injunction that goes into place. And that means that everybody cannot spend or hide money excessively. They must just do so in the ordinary course of living and business. And so there are other mechanisms besides a civil protection order. These are a few of them. And I'm not talking about the criminal realm, of course. I'm just talking about the civil realm because that's what I do. Here at a civil temporary protection order, there are 2 prongs that must be proven. That goes on into the permanent protection order, that this act occurred, this violence occurred, there was an aggressor, it was an intimate partner violence, it occurred against someone. That can be physical, that can be sexual, that can be emotional, it can be financial, it can be domestic violence. But let me tell you, the bench book in Colorado says it has to be more than words. And so if you end up actually going and trying one of these cases, or you are a victim and you are trying to get assistance, it is important that you understand that we need more than words, because you probably will lose a case just on that. We're looking more for a pattern of coercion and control. And the second prong is that these acts that are prohibited are likely to continue unless restrained. And any lawyer that's helping someone through this process has to focus their evidence on both of those prongs. What is my assessment of what actually happens? And I practice throughout the state. What happens is the county matters, the judge matters. I'm just going to be really frank here. I don't know this organization as well as the rest of you do, so I don't know exactly who's on today. But if you have a civil protection order case in El Paso County, if you have a civil protection order case in a small rural community, you are less likely to get that civil protection order, hands down. Doesn't matter how much judicial education we've had so far, there is some implicit, and actually more than implicit, express bias that is going on in our system. That means that unfortunately, survivors are going into courtrooms where there is sort of a sense that it is hard in this courtroom to get a protection order. And all you have to do is talk to your local domestic violence agency to find out which one that is in which county you're in. Now, there are others, say Denver, others, where it's much easier, where there's been a lot of education. Now, it doesn't mean that the burden isn't met. That doesn't mean that somehow the victims are favored. It just means that, in fact, there's been a lot of work done in that particular county, which makes it more viable to get a protection order. He said, she said, cases remain very difficult. The fact of the matter is the burden to show the evidence remains on the person bringing the civil protection order. That puts an enormous burden on, the survivor, the victim. It's difficult to have that right evidence. There's lots of reasons why it's difficult to have that right evidence. Let's be candid. People don't want to remember what's happened to them. They don't want to remember what's been done to them potentially over the course of a very long, say, marriage or relationship. So they don't save evidence. They don't hold on to those things. And then when they go and they actually have to get this protection order, it's very difficult for them to provide a linear explanation of what happened. And our judges are looking for a linear explanation. And so an effective lawyer's job is to explain what's happened to a person, to help them go on to that memory lane, so to speak, remember what's happened, and then essentially tell their story in front of the judge and help the judge understand what the impacts of that trauma are. And reality is that the legal process itself creates trauma. We actually heard Majority Leader Duran say that. I thought her story was amazing and powerful. If you are still here, thank you for sharing that with us. And what I want to say is that's really true. I mean, there's just no way someone's going to go through the legal process without being re-traumatized. And it's really hard to be with them as they do that. And we need lawyers that understand this and that are willing to do that. And the reality also is that courts sometimes don't get it right. So you've got someone who's experienced years of domestic violence, who really needs a protection order. They finally get to the point where they can go forward. They decide they're going to do it, and then they lose. And now they have the double whammy of having been an abused person, and then they go into the court system, and the court system does not validate their life experience. Really evaluating with someone ahead of time what it is that they're hoping to accomplish. One of the things I tell my clients is frequently, you accomplish something by coming and asking for a protection order, whether or not you are successful. Because even if you weren't successful, the person who did this to you will think twice before they continue to do it to you, because they know that you're willing to stand. So I really try to work to empower the person in front of me and stand beside them, obviously, give them as many tools as possible. But they have to testify, they have to tell their story, and they have to tell their story in front of the person who did it to them. And sometimes they have to suffer while that person actually asks them questions, because if that person doesn't have an attorney defending them, then they get to actually ask questions of the survivor during the protection order hearing, which can be brutal. That is something that would be helpful from a trauma-informed perspective. If a judge could ask questions, if there was a directive that the person who has the protection order claim against them could ask the question to the judge, and then the judge would ask the person asking for the protection order. I've seen that done in some courts. I think that's very friendly, and it's really respectful of the dynamic. And so that would be a recommendation that I would have going forward that is trauma-informed. I want to talk for a brief minute on the United States versus Rahimi. Some of you might be familiar with this case. This case came out a couple of months ago, well, maybe now 6 months ago. Rahimi is a situation where this was a U.S. Supreme Court case, and it's from Texas. And Rahimi assaulted his ex-girlfriend and threatened to take away their shared child. A Texas state court found that Rahimi had committed family violence, and that was likely to occur again in the future. Every state has a different way that they use the language, but you can see that's very similar to our civil protection order, which is there's some violence, some act that occurs occurred, it's likely to occur again in the future. So it really tracks what our statute does as well. Unfortunately, Rahimi ignored the protection order. He had guns. He didn't get rid of his guns. He threatened his ex-girlfriend. So he violated the order. So the police the DA, the police, they actually arrested him and they charged him with violating that protection order. The question that the Supreme Court was asked as this went up the chain was whether the challenged regulation was consistent with the principles that underline our regulatory tradition. That's a lot of legal speak that essentially just means when you are convicted or not convicted, when you have a protection order against you and there's intimate partner violence, you have to release your guns. And so he fought that. He said he shouldn't have to release his guns under the Second Amendment. And thankfully, the Supreme Court, even though it's packed by Trump supporters, the Supreme Court said that it did not violate the Second Amendment. And this was a huge win. Now, what does this mean in Colorado? I had a client that I had originally helped get a civil protection order years ago. And the person that was against, her now ex-husband, had tried for years to change the protection order. Each time she would find me at whatever organization I was working at and ask me to represent her in fighting a modification of the protection order. So as this case was coming up, he was watching, and he and his attorney filed a motion to modify the civil protection order in Jefferson County. She found me where I now work, and I represented her. And they actually asked for their case, their modification of the civil protection order, to be stayed until this came out. And they were relying on this. They were ready to pounce and basically say, this cannot stand because of United States versus Rahimi. Because we had the evidence that at the underlying hearing where the protection order was originally found, there was significant gun violence. There was significant threats against my client by her then husband with guns. And so there was no way substantively they were going to win, and they knew it. But they were ready to come in and use this case, had it gone their way, to basically endanger my client in that instance and many others. So that's why it really matters what's happening and why it's really important. I was asked to talk about action items, and these are some specific things that I personally came up with. Some of them are things that you all know that you're just going to say, yep, that's right. Consistent and effective firearm removal. We need to make sure, and this process in Colorado has gotten a lot better, and some of you are probably the reason why it has, so thank you. Improved law enforcement of protection orders. Again, this process in my 19 years as a lawyer has gotten better in Colorado. So thank you. I have in yellow here the things that I particularly would say. I know I said one of them earlier that wasn't on this list that I just thought of, but I would like to see more flexibility in protection orders. The police have a little box, and this little box is where the exceptions to the protection order come up. And you will hear a judge say over and over and over again, it's got to fit in the little box. In other words, the police don't have access to the protection order. I have no idea. I'm going to just appreciate all of you policy people about how we could make that happen. But why? Why don't the police have access to the full protection order that includes those exceptions so we can have more clarity? So that I think that would help enforcement, so that the judges aren't worried about this little box, and we can really say what needs to be said. So that's one suggestion I have. Another thing is that we say these are permanent protection orders, but that's really not true. After 2 years, someone can come in and they can fight the protection order. They can ask for it to be modified or even go away. And I get hired in those hearings, right? From victims who don't want that protection order to go away. And so I think a longer period, even if we just get to 3 years or even 5 years, because 2 years sometimes is not enough. Let's be honest. If there has been a relationship that has happened for 20 years, 2 years is just a short period of time. It's not enough to make the situation go away. So that's another example. And then mandatory counseling and education for offenders. We have that in the criminal system. I would just like to see that if someone gets a protection order against them, one of the requirements that they must do is take some kind of domestic violence class, take some kind of anger management class. And especially if they are asking for the protection order to be modified, if they are asking for the protection order to be modified, they have to show that they haven't violated it. They have to show that they haven't had any criminal cases against them. And I think they should have to show that they went and they took some kind of domestic violence education class, and that should be one of the elements that they should have to take in order to ask for a protection order to be removed. I have some other things here too. I mean, increased training of lawyers and judges, all of the things that we already know. But I tried to think outside of the box and provide some ideas that at least I haven't in my daily practice heard. And thank you for your grace, knowing that I'm just in the trenches. I represent, about 45 clients at a time. And that's the work. I'm in the courtroom and not in the policy arena. So thank you for listening to me today. This is where I can be found if you have any questions. I appreciate being here today. Thank you for all of your work. My entire career has been focused on helping women, and I've done that through VAWA and all of the state assistance, not just federal, but all of the state assistance. So we really appreciate the work that you're doing on behalf of the people that I represent. It actually really means the world to them. As Monica Duran said, this is life and death for these women, sometimes men too, admittedly, for these victims of domestic violence of any kind. This is critical. Thank you for your, support for VAWA.
Thank you so much, Shelly. And I know that there are probably a ton of questions that people will have. So I just encourage you to put them in the Q&A, and we will come back after our third panelists today. So with that, I'm going to go ahead and introduce Elizabeth Newman, and she is the Public Policy Director for Colorado Coalition Against Sexual Assault, CCASA. I'm sure we've all heard of that, but she's going to go into much depth in terms of explaining exactly what that really is. Prior to joining CCASA in 2021, she was the Policy and Projects Director at the San Francisco Department of the Status of Women. I didn't say that right, at the San Francisco Department on the Status of Women. There she developed policy, advocated for state and local legislation, directed research, and provided technical assistance to further women's economic opportunities, address gender-based violence, and foster the equitable treatment and advancement of women and girls. Elizabeth previously worked at the San Diego and Imperial Counties Labor Council, AFL-CIO, and on various candidate and issue campaigns. She has a BA in Women's Gender and Sexuality Studies and Sociology from Macalester College and a Master of Public Policy degree from the Price School of the University of Southern California. With that, we are so pleased to welcome you, Elizabeth, and it is your turn, so take off.
Thank you so much, and it's just such an honor to be in this room with so many amazing women leaders, and so I just really appreciate the opportunity to talk about CCASA and the work that we do. We are the state's anti-sexual violence coalition, so our members are rape crisis centers, dual domestic violence and sexual assault agencies, campus-based programs, sex offender treatment providers, therapists, and survivors themselves. And we work to provide education, technical assistance, referrals, systems change initiatives, and public policy advocacy to address and prevent sexual violence here in Colorado. We talk about sexual violence, and I just want to take a minute to explain what that means. While we are the Coalition Against Sexual Assault, sexual violence is a broader umbrella term that really talks about the range of unwanted sexual behaviors. And so these are things, we think about regularly with contact sexual violence, so things like rape and childhood sexual abuse, to things that are more of a degradation or an exploitation, unwelcomed advances or sexploitation, where someone is using power to try to exploit sex or sexual images from someone else. And then we have just our underlying rape culture in America. We know that sexual violence is pervasive, and that can be unsolicited nude photos, catcalling, locker room talk, and obviously the sexist attitudes that just exist in our society. And what we know is that the tolerance of these behaviors at the bottom supports or excuses those that are higher up or more severe. So in order to change our overall incidence of sexual violence in our country, we have to change the culture and check the lower offenses in order to really move towards a society that is free from sexual violence. One of the things that I really like to highlight for people when I talk about what sexual violence is how it impacts so many different aspects of an individual's life. There are immediate physical health needs for injuries or STI and pregnancy prevention. There are also longer term issues that are widely documented for survivors, including gynecological issues, chronic pain, GI issues, those types of things that people don't understand are really connected to a root of trauma in someone's body. And then initially, emotional issues are one of the top needs for sexual violence survivors. 94% of people who are raped experience PTSD within the first 3 months. And that often drops down to about 60% that those symptoms continue on for a year. So that high level of trauma just remains in them and affects their ability to form healthy relationships, their ability to keep their job or stay in school, their ability to have relationships in the future. And then oftentimes that trauma is treated through substance misuse. There can be suicidality or other behavioral health needs. So the impact is primarily on an individual, but it is wide ranging in how it affects someone. And then on a broader societal level, those things have costs and consequences to businesses, communities, and our society at whole. And then sexual violence affects everyone. Anyone can become a victim of sexual violence, but it is used as a tool of power and oppression. And so therefore it affects those who are most marginalized at higher rates. 18 to 24, especially women, are the highest rates, at the highest risk of experiencing sexual violence. More than 4 in 5 female victims had experienced sexual violence before they were 25. So that's nearly everyone. And for male victims too, about 70% of male victims experienced sexual violence before age 25. Among LGBTQ populations, there is an incredibly higher rates of victimization of all forms in comparison. And we really see with sexual violence, actually the highest rates among bisexual individuals and then also transgender people. With communities of color, 2 in 5 Indigenous women experience rape. And it's a really, really high number. It's also incredibly high for Indigenous men, very similar rates. We have 1 in 3 Asian women, 1 in 4 Black women experience sexual violence. And so again, we see those really high rates because these communities are already marginalized. And then people with disabilities have twice as high of rates of sexual violence. When we break down these statistics, when we look at kind of the whole range of sexual violence behaviors, we know that the vast majority of women have experienced some form. And when we think about the intersection between age, sexual orientation, race or ethnicity, and disability, that makes someone especially vulnerable to this experience. And then those consequences are then increased because, of course, there's also a high rate of a lack of services, a lack of support And so those consequences to their mental health, to their physical health, and to their economic well-being are also increased. And so with those, that kind of primer on sexual violence, these are the priorities that we take when we look at policy interventions. As I mentioned, CICASA is focused on addressing, but also preventing sexual violence. And so when we address the impacts, we are looking mostly at what are the needs of survivors, expanding their rights and protections within our systems, within schools, within the court systems, within the medical systems, increasing accountability for those who have caused sexual harm. We cannot check those behaviors if we do not have accountability. However, that can look like a range of things. CICASA supports survivors whether they choose to pursue a criminal case, a civil case, restorative practices, or their own support and healing. And then we also work to remove those barriers to survivor services and support, especially for those marginalized groups who often lack access and struggle to find responsive and culturally sensitive services. It's incredibly important that survivors' autonomy and healing and justice are returned to them, that ability to choose. We've worked to expand reporting options so that someone could go get a medical forensic exam to have their injuries treated, to have evidence collected, and not be forced to report to law enforcement. So we did create a medical reporting option where that care can be provided and analyzed, the evidence, but it doesn't necessarily respond to a law enforcement report, and also anonymous reporting options where someone can go and their information is not even provided to law enforcement. It's really in their hands whether or not they want to engage that system. And then preventing sexual harm. Some of those pieces around prevention include economic support. So when women and children and people in marginalized communities have more economic opportunity and support systems, they are less vulnerable to sexual violence. But it also includes things like promoting gender norms that are equitable. So the work of AAUW and other organizations like that are really beneficial for preventing sexual violence by creating an environment that reduces the likelihood of sexual violence. And then the last, we often think about things like consent education and sexual education that is really teaching young people how to engage with each other in a healthy and pro-social way. So this year we have 2 bills that we are primarily working on, although we have many others that we are going to be supporting or engaging with. Our first bill that's been introduced and is actually going to be in the House Judiciary Committee on Tuesday is House Bill 25-1138. So this bill, we are working closely with the Women's Bar Association to co-run the bill. And what we are doing is updating Colorado's civil rape shield law. Last year, the district attorneys expanded Colorado's criminal rape shield law. And this is a law that protects information about the victim or in the case from being introduced into the hearing, the court hearing, without some kind of level of protection. And that is to reduce the trauma for victims and survivors, but also to ensure that there's a fair trial by not introducing evidence that might promote stereotypes or biases against survivors. We know the myth of the perfect victim, that someone must be, white, young, pretty, and had not drank, been wearing, not wearing any clothing that might be suggestive in order for their case to be successful. And these laws are an attempt to undercut that myth that there can only be perfect victims. And so with the expansion of the criminal rape shield law in 2024, we are now expanding the civil side. So in civil cases, we are putting in a couple requirements by restricting evidence about a survivor's sexual history and hairstyle or manner of dress, except unless that evidence is to show a change in those things as a result of the as a result of the incidents. And then also to ensure that there are hearings that review that evidence that might be introduced prior to it being introduced before the jury. So it's a kind of a closed door review to ensure that it's relevant and it's not just going to promote those biases. So that bill is coming up. The second bill that we have coming forward has not yet been introduced, but will be co-primed by our wonderful Representative Meg Froelich. And this bill is really to fix a couple challenges we have in the court system related to parental protections for survivors when there is a child from sex assault. So 10 years ago, Colorado passed a law that allowed survivors a process to terminate the parental rights for their assailant. This is that, you know, it's in the best interest of the child and the victim survivor for that person to not be, have access to the child, have responsibilities to them. And so this law we thought was done, and in recent years have learned that it's actually inaccessible. Survivors who have brought these cases forward have been, you know, just turned away from the court system and required to go into custody disputes or dependency and neglect cases in order to access this. And this law was actually set up to prevent that requirement. So we are requiring that the juvenile courts hear such cases and actually modify their forms so it's communicated to the public that this is available. On the flip side, we know a survivor who relinquished the child that she became pregnant with from assault, and she had sought abortion, but was actually went to a crisis pregnancy center. So she was talked out of it. She had tried to give the child up for adoption, but the father would not sign off. And so she signed over the child because she could not. She was 19 years old. She had no family support. She could not raise this child. And in the years since, she has been held to pay child support. And so this bill would also address the relinquishment of parental rights for victims to reduce the trauma of that process and eliminate the cost. The cost of sexual violence is already great for victims and survivors. The cost to be forced to bear a child that you did not wish to have is already such a burden. We want to make it easier. So that bill should be coming forward very soon. And then I would be remiss to not mention the impact on the federal level of the federal funding freeze. While there is a temporary protection order restricting the Trump administration from enacting the freeze, at least in Democratic states, including Colorado, who have filed that suit, there is still an effort to restrict funding that promotes gender inclusion, that promotes diversity, equity, and inclusion. And those are what the federal government has asked of programs over several years. And as I showed earlier, there's a very good reason for those programs to be in place. So grant funding is at risk here in Colorado. And as you heard from Rep. Froelich, the state does not have the resources. We had to pass Prop KK in order to even be able to supplement what the federal government is funding. And without that funding, we are going to see a collapse. Organizations like CICASA and anti-sexual violence organizations are not well funded by foundations. They do not receive large amounts of donations. People do not feel comfortable talking about sexual violence, and so therefore they don't seek to fund it. It's not a feel-good type of issue that people want to, give money towards. And so these services, through the grants through VAWA, the Victims of Crime Act, Rape Prevention Education, and Sexual Assault Services programs are potentially at risk of being cut entirely. The Trump administration can eliminate grants that it has already, that have already been granted. And so that is a major concern for Colorado and for our services here. So with that, here is my contact information. You can feel free to reach out at any point. I do really appreciate the opportunity to talk about these important issues and to really connect with all of you.
Elizabeth, thank you so very much. And thank you for including your contact information. Darcy, we'll go to you for questions. And again, this has been such a rich panel of so much good information. And I thank you all three of these panelists for tremendous information for providing for us. So Darcy, take it away with questions.
All right, I'm happy to, and I see all three of our panelists have turned their screens on, so that's great. I have a first question from Wanda Marker, and she says, the Fed has issued an order to take down all women-related content by January 31st. The federal websites are down as agencies implement an executive order that they say will defend women. How will that affect Colorado at the state level? And that's for any one of you.
Yeah, I'm happy to speak to that. In an effort to defend women, we are eliminating any information about gender and sexual orientation. Just in putting this presentation together, I went to the CDC's website to find the National Intimate Partner Sexual Violence annual survey and report, and it is missing. So you know, it does threaten services, as I mentioned, the funding there, but it also threatens our understanding, the research, the data, the awareness of the way that these issues affect women, and especially women from different communities who do face those higher rates of violence. So it is a huge threat, and we do not have state funding to fill that gap. So the loss of federal funding is incredibly devastating.
Thank you. Mary Korch asks, with rape jokes and threats in high schools and colleges, does Title IX address this, or is this an issue for the courts? And what's the option for those that are threatened when the school doesn't follow through after reporting?
Yes.
Well,
Title IX has now returned to the 2020 regulations. And so that was just under a court order, that work that the Biden administration had done to expand what can be covered under Title IX has been restricted. And so if it is sufficiently creating a severe and pervasive level of harassment, it could fall under Title IX. However, in Colorado in 2023, we passed Senate Bill 296, which creates harassment and discrimination protections for all forms of harassment and discrimination, including sexual harassment, that does provide an opportunity for schools to address that and to provide supportive measures for students who are experiencing that, and to have some data reporting. I will say the one shortcoming is there is not a strong enforcement mechanism. And so for schools who do not follow through after reporting, there is very little that can be done because the federal government, Title IX, Office of Civil Rights is, in flux, and because our state protections do not have a high level of enforcement. And I don't know if anyone has other thoughts, but it is a challenge, particularly when schools are failing to address.
I was just going to add that, of course, those individuals that experience that can come into our courts and ask for a civil protection order. And we see that. We routinely see that. We sometimes see schools come in and join them. We sometimes can actually subpoena the school and have the school testify and have the school records. So that's another option, rather than the school initiative, just the individual initiative, and then collaborating with the school.
Thank you. This is a question for Meg Froelich. When this summer the Proposition KK funds start to be distributed?
Yeah. That one we're in communication on email, so we can skip that one.
Okay. Well, the question was, did you have a favorite project that you'd like to see funded?
Oh, no. I mean, the way we passed the bill, and we'll be super quick because I know there are other questions. The way we passed the bill was to say that we weren't reinventing any wheels. So the funding had a normal process that it went out to. And so when it collapsed, this was simply expanding it back to its original.
Great. And then there is a question about the problem of the backlog of rape kit processing in Colorado. says news reports indicate that Colorado has more than 500 rape kits waiting for processing. What's up with that, and how long is a rape kit viable?
The evidence lasts for a really long time, so that's the good news. But and Elizabeth and I have worked on this now on 3 bills, I guess, on rape kits. So we did great work in Colorado and got at our backlog. This actually stems from, and you've probably seen on the news, that one individual at CBI who falsified evidence over a decade. It was over a decade's worth of evidence, and threw the whole process for a loop. So there are 500 rape kits that have not been tested. And this not only affects cases in criminal court at the moment, but I and Elizabeth can speak to this, but this is how we catch cold case folks. So it's tremendously important to, and also tremendously important to survivors in terms of dignity and justice, to have these rape kits processed. So we desperately wanted to put money into this year, and now we're hit with this, not only the usual Tabor where we can't do anything new and exciting, but this $600 million cuts we're going to have to make. So and just again, it's Tabor. Tabor allows us to grow by population and inflation. We have a good economy, which means inflation is down. And so this crazy formula has us cutting $600 million from a budget in which our state is actually doing really well economically. And as if growth can be measured by population influx. We really want to grow smart. We want to grow well. It isn't covered by inflation and population growth, but that's my Tabor soapbox. Sorry to get off topic.
Thank you. That's an important one. So we have just 2 minutes left for questions. I'll ask one more, and perhaps this is for Elizabeth or Shelly. We've seen what dramatic changes a woman can make in her life if community support is available. This is from Cheryl Spratz. One major hurdle, though, is making contact with the victims. How can communities reach out to their victims?
That's such a good question, and it's so critical. And that is one of the really concerning parts about these funding decreases, is that it only allows programs to get to the people who are at their doors, who are calling, who are in crisis and connected, versus the outreach and education that they do. It's really important that schools partner with service providers. That's one great way to make sure that young people who are really at risk of sexual violence, intimate partner violence, and others know what that services are available. And it's also really important that we have outreach and education in language, in culturally responsive formats, so that people feel that they can be connected and met and be honored for who they are. And that's a big piece. And I know it's something that's always a challenge with reaching out to different communities, but just awareness like this space is such a great opportunity to just let people know that these services do exist. While we are at risk of losing funding, they continue to exist. They continue to meet the needs of survivors as much as they can.
I just want to quickly add that basically billboards and radio ads and those kinds of things are the things that I think get to the people on the street. Obviously not just in English, I agree with that. But I really think that if you have whatever your local agency is, whether it's the Rosandom Center or some other organization in those areas, we need to see that. Because that's what people see. They see it and they start to think, oh, this should not be acceptable. There are ways to get out of this system. But that's how they hear about it, through really billboards or like bus station ads, those kinds of things on the back of bathrooms. When you go to somewhere and see that, that's what we need more of, I think.
Thank you all very much. This has been quite enlightening, and I'm going to turn it back over to Nancy Todd, and we'll see our second panel.
Thank you so much. Great questions and interaction. And, I can't help but think all the ads that are on TV for erectile dysfunction, wouldn't it be nice to offset with some of the suggestions that you all just made? So a lot of work for our legislators and for each and every one of you. Thank you so much.